Well, hi there, and welcome back to another episode of Let's Talk Real Estate Investing. I'm your host, Sharon Vornholt, and I'm so happy you're tuning in today. Today, I want to dive into what happens to rental property during probate. And this is important if you are trying to buy a property that's in probate. You need to know all the nuances involved and what may be going on in the background. I'm excited to talk about this because not many people know what they could or can or should do in this situation. So, specifically, folks want to know what happens to the rental income during the probate process. And today's show, I'm going to answer that question as well as some other questions that come up quite often. But by and large, the biggest question is what happens to the rental income. Now, I've talked about the actual probate process a lot of times, but let's go through that real quick. So someone passes away, the probate is opened, and then either the estate is testate, which means the deceased has chosen an executor and they are named in the will, or it's intestate, which means there's no will and the court will appoint an administrator. Both of these people are referred to as a personal representative. So once this is over, and there are other things going on in the background that you don't need to really be concerned about as an investor. But once you have the decision maker, the personal representative, then the assets in the estate are sold. That's any property. The creditors are paid and the heirs get what's left. And then the estate is closed. So that is pretty much a straight line process. Now, some people will open the estate quickly. Some people will wait 4, 6, 8 months. And there are other people that'll hit closer to the 1 year process. And bear in mind that all during this time period, if you have rental property, in theory, the rent is still coming in. If the tenants still live there, the rental income should continue as long as the tenant continues to pay rent each month. That's how it should work. Now, if the tenants stop paying rent, that's a different matter, and I'll go over that in just a minute. But you need to know the rights and responsibilities, what they are as a property owner or as a property manager, and certainly as an investor, according to the laws of your state, because this will determine how you react to these situations. And your probate attorney or your real estate attorney will be invaluable in helping you with this process. In my area, I found that my real estate attorney knows a lot about probate, and he is my go-to person. So you understand the probate process, and you know what's going to happen during that process. So you know then who takes care of everything. Well, that's the personal representative, the executor or the administrator. They will need to manage the property, and that includes collecting the rent, and that includes making any repairs or taking care of any problems that crop up. So that's their job during the probate process. Now, the rental income should ultimately be deposited into the same bank account that the estate has. So this account is set up when the estate is opened. You don't really need to know this, but there's a tax ID number, an EIN for the estate, and all the money that belongs to the estate is supposed to be put in this bank account. And that's so that any expenses that come due would also be paid out of the same account. It's vital that the personal representative keep detailed records because there is going to be an accounting of all of this. Now, if there was a property manager, there might be property management software in place where tenants paid their rent online. So any rents could continue to be entered into the system, which makes it easy. And from an accounting perspective, it makes things so much easier. But if that's not the case, if the rent was paid directly to the property owner or the property manager, however, by check or money order or whatever, then you're going to have to account for all of that money. That money is going to have to make it into the account where all the funds from the estate are deposited. Now, another question that comes up frequently is, Can the heirs have access to the rental money before the probate is completed? Sometimes they think this is just a new source of income for them. And the answer is no. They cannot have access to it. The executor, the personal representative, can have access to it to pay expenses for the property. So this is for the income producing property. It should be noted that the executor collects the rent on behalf of and solely for the estate's benefit. You really need to get this. So that executor, they collect the rent on behalf of and solely for the estate's benefit. Now, where this property is concerned, that would be to take care of any mortgage payments, any expenses that come up, anything like that, any repairs. So that's what that means. Now, here's another question. What if there isn't enough money coming in from the rental property? Maybe a couple of people stop paying. What if there's not enough rental income coming in to take care of the expenses associated with the rental property? You would then need to look at the estate and see if there's money in the estate bank account. Now, remember that if property is being sold, as assets are being liquidated so that the heirs get the money at the end of this process, it's likely that there's money in this account. There may have been money in a bank account left behind by the deceased. So look to the estate account. And this is, again, for your knowledge, if you are buying a property that's in probate, you need to understand how everything will be handled. And now you know that the executor, the personal representative, can sell the property once they get to that stage in the probate. They would also be able to take care of, let's say, if it couldn't be sold, if there was a tax lien on it or something. The executor is the decision maker, and they will be your go-to person in figuring all of this out. Now, if the heirs squawk at not being able to get their hands on the rental income, because some people think in their mind it's just money that's going to come to them eventually, you should refer these folks to the attorney involved with the estate. You wouldn't need to deal with this. The executor wouldn't need to deal with this. That's an attorney thing. So they shouldn't be worried about that. And oftentimes if you're looking at probate property and there's a lot of drama in the family, one or more of these things could come up. And the reason I'm talking about this today is so that you'll be armed with the knowledge of how to handle this, and you won't be surprised if and when something like this comes up, which, by the way, is almost never, but it has happened and it could happen. So moving on, what if the property becomes vacant during the probate process? For instance, maybe the tenant moves out and the rental income was actually needed to take care of a mortgage that's on the property. Maybe the rent pays other expenses. Almost certainly it's responsible for paying other expenses. Can the property be rented out if it becomes vacant? Well, the short answer is yes. The executor can rent the property. However, you should check with the attorney involved in this process to find out if it has to be rented on a month-to-month basis or if you can have a longer lease. Let's say that you're getting toward the end of the probate and this property is ultimately going to be liquidated or whatever the scenario is. You may not be in a position to put a long lease on this property. So know the specifics of the situation and know the laws and consult with an attorney so that you know that if you sign a lease or if the owner has signed a lease, that it is correct, because you really don't want to buy a property that's in a big mess as far as an estate is concerned. Now, there are a couple of other potential problems you might encounter with regards to tenants or people living in the house. And number one is, what happens if the tenant stops paying rent? What's your legal recourse? And number two, and this happens more than you might know, a family member is living in the property without a lease and they refuse to move out. This would happen maybe in a scenario where a family member moved in to help out with things where the deceased was concerned. Maybe that person was ill, but for whatever reason, they are residing in the house and they refuse to move out. So if you manage property for yourself or for someone else, this actually could happen, especially if the tenants find out. In the case of it, when the tenant stops paying rent, they might find out that the owner is deceased, and they might just simply quit paying the rent. They may quit paying the rent for other reasons, and we'll talk about the way that's handled in a minute. But for each scenario, the executor of a probate estate has the authority to file what is called an unlawful detainer. Now, if you're a landlord and you have property, you're going to know what this is. But if you're not, maybe you're just an investor, but you don't have any property, you're not going to be necessarily be familiar with this. But an unlawful detainer is a legal way that a landlord evicts a tenant. It requires a special court process, and it can move quickly through the court system, and sometimes it moves slowly through the court system. You should know that an unlawful detainer can be filed even if the person living in the house that's being evicted is a beneficiary under the will or an heir of the estate. Remember this, everything is going on for the benefit of the estate. And if someone is living there that doesn't have the right to be living there, they can be made to move out while this whole process plays out. And this will happen when you have a contentious situation with regards to tenants and family members and the probate. So to go back a little bit, the executor would be doing this for one of two reasons. The first reason would be to evict a tenant living in the house owned by the estate. Once the deceased is deceased, the estate is owned by the property is owned by the estate. The second reason would be to evict a family member living in the property now owned by the estate. In either case, the general rules of an unlawful detainer apply. Now, if it's a tenant, you're going to want to find the lease like you would in any other situation and know what the terms of the lease are. If the person living in the home is a family member who agreed to pay rent and therefore has a lease, they can be evicted using a 3-day notice to pay rent or quit. This notice is the first step in the eviction process in this situation. So a 3-day pay or quit notice is served by a landlord to a tenant after a breach in the lease agreement, most commonly for non-payment of rent. And once again, I want to go back to the thing of be sure that you're consulting with an attorney. Be sure that the laws of the area where you're living are the same as what I'm quoting here. So things do vary from place to place. That's just the way it is. Now, if a family member who lives in the family home and does not pay rent, they would still be required to be given a notice. So they were there, they were living in the home, and they weren't paying rent, and you want them to move out, you still have to give them a notice. Generally, a 30 or 60-day notice to quit would be used in this situation. Just check that out for yourself. So that, as you can see, in each one of these situations, there are a little bit different methodologies for how you get the person out of the property. So why should you care? Well, you should care whether it's going to take 30 or 60 days to get the tenant out, or if it's going to take 3 days or a week or something like that. That will make a difference to you if you're buying a probate property. So understanding how this works is really important if you get into one of these situations. Here is something to know, which I find that is a little bit fascinating, and that is that an executor can evict someone that ultimately stands to be an heir of the estate. Now, this is not the same as someone who's inheriting the house, like a survivorship deed. Their name is on the deed. They've been named in the will as the property will be deeded to them. These are all attorney things that are way above my pay grade. But if someone stands to ultimately inherit money from the estate, that does not mean they get to live in the house rent-free. It does not mean they get to live in the house at all, in fact. So understand that they can be an heir, which could be a situation where they're splitting up the assets among a number of people, among many people, and they are simply one of the heirs. So they're not allowed to just stay in the property rent-free, as the house is the property of the estate, as I said. One thing to note is that you should file an unlawful detainer in this situation sooner rather than later, as this gets a little bit trickier and it may take a while to solve this situation. As a general rule, if the executor or personal representative intends to sell the property and it is occupied by a family member, you're going to want to take care of this before you ever try to sell the property. This is something that that the executor has to take care of, and is not something that the new owner would be saddled with. So I hope that makes sense to you. You wanted to get all of this sorted out before you take any offers on this property in the estate. Now, and one thing I'd like to really point out here is that in all my years of working with probate since 2018, I've only had one real situation. Most of the time it goes very smoothly, but when you're armed with this knowledge and you can help people in these situations, it's just one more notch on your belt as being a probate investing expert. It's not really hard to learn, and you just need to have the knowledge that this is how this works, so that you can help the person that's trying to sell the property. Okay. Well, I think that's it for today. If you have any questions, email me at sharon@sharonvornholt.com. And be sure, if you're thinking of working in the niche of probates, be sure to get my freebie, my probate investing starter kit, which has a free sample probate letter and some other things. Also, there's a ton of information over at the Louisville Gals Real Estate blog and on the podcast, Let's Talk Real Estate Investing podcast, for free. You can get started there. You can search by topic on the blog, and that'll bring up all the videos, all the podcasts, all the blogs on probate investing. So, knowledge is power, and knowledge is directly related to the number of dollars that you put in your pocket. So know that. If you want more information on probates, check out my course, probateinvestingsimplified.com. As always, thanks for tuning in week after week. I do appreciate it. I would also appreciate it if you would leave us a rating and a review over on iTunes. And I will see you same time, same place next week. Bye for now.